Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Ms. Brady, Ms. Nelson, and Ms. Higgs, and the prosecution is represented by Mr. Orman, Ms. Pearson, Ms. Stitch McGuire, and Mr. Edwards. We are outside the presence of the jury, just as we were throughout the day yesterday. Late yesterday at about 8 o'clock, I had my staff email the parties the latest drafts of the instructions that we worked on yesterday. And just so that the record is clear, those instructions are the sentencing hearing phase 1 introductory instructions, the phase 1 final instructions, and the sentencing hearing phase 2 introductory instructions. I made all the changes that I indicated yesterday I would make based on the discussion I had with the attorneys. In addition, I added some language to the introductory phase 1 instructions and to the phase 1 final instructions to address the concerns that were expressed yesterday by the defense in terms of having the jury uninformed about the merger issue. And so I've added some language with respect to that. It's still not what Ms. Nelson asked for, which was to do the merger now and tell the jury about that the counts have been merged. But it does inform the jury that that will eventually happen at some point, and that there will only be 12 convictions for murder in the first degree, and that there will then be a sentence per each of those 12 convictions. In other words, 12 sentences for first degree murder. I made some changes this morning after I had already sent this to you last night. I wanted to get these to you last night so you would have a chance to review them before you got here today. The changes that I made this morning are all as to form, with one exception. In one of these instructions, I think it's in the phase 1 introductory instruction. It is on page 2. It says 134 offenses. It's referring to the fact that it is not the jury's responsibility to determine the punishment for the other 134 offenses of which the defendant was found guilty. I think that should be 141, not 134. And I took that from the defense's standard instruction, but it should be 141, because 165 minus 24 is 141, right? So I made that change. The other thing I want to talk to you briefly about is whether either side is asking me to give the jury a copy of the introductory instructions. I wasn't planning on it. My plan was to simply read the introductory instructions. I would then turn to counsel and ask, do you have any evidence to present? My expectation, based on the representations that counsel have made, is that counsel will say, no, we don't have any evidence. That's the prosecution. I will then ask defense counsel the same. They apparently don't have any evidence either. I will then have my staff distribute the final jury instructions for phase 1, and I would read those to the jury and have them follow along as I'm reading them to the jury, and then go over the couple of sample verdict forms at that time. We would then probably take a break, and then we would start with closing arguments after that, going with the people first, going with the defense next, and then the people's rebuttal, if any, at the end. During the closing arguments, my staff, a couple of members of my staff will be busy in the back taking all the exhibits back into the jury room so that the jury can start deliberating right away after closing arguments, so that there's no delay. That'll probably take about a half hour, and my expectation is that closing arguments will take 30 to 40 minutes anyway, so I think it'll work out fine to do it that way. Is anybody asking me that I give the jury a copy of the introductory instructions, Mr. Orman?
No reason for that, so we're not, Your Honor.
Okay. Ms. Brady or Ms. Nelson or Ms. Higgs?
We would like the jury to have a copy, Your Honor.
Oh, okay. And I don't have a problem with them having a copy as long as we take them back. So I'm happy to distribute them. I think it helps actually to have it in writing as I'm reading it. I'm going to be reading anyway, and it's boring to listen to someone read something to you. So if I'm going to be reading them, I think it's helpful to have them follow along. But what I would do is then retrieve those instructions from them and then ask the parties at that time if they have any evidence to present. When the parties say that they don't, then we will distribute the final jury instructions. Those they will keep, and they will take to the deliberations room with them. Does that sound like an okay plan to everyone?
That sounds fine, Your Honor. I beg to differ. I think when Your Honor reads things, it's actually very interesting.
Okay. Thank you. All right. Let's talk about the instructions then. Let's start with the final instructions, the phase one final instructions. Do the people have any other objections or any other suggestions or any other instructions to tender in terms of the final phase one instructions?
The only thing I noticed, Your Honor, is in the instruction that lists the elements of the statutory aggravating factors, which starts with "at this phase of the sentencing hearing."
Yes.
On the third page of that, Your Honor, in the, what I would call the paragraph that says, "in order to prove beyond a reasonable doubt," which is about 6-7 lines down, on the third line of that, the term aggravator is used instead of aggravating factor.
You're right. Okay, I will change that just to be consistent. Thank you for catching that. I'm assuming there's no objection to that, right, Ms. Nelson?
Changing aggravator to aggravating factor?
Correct.
No objection.
Okay. Thank you. All right, anything else, Mr. Orman?
Your Honor.
All right, how about from the defense? Ms. Nelson, any other objections or any other instructions that you want to tender with respect to the phase one final jury instructions?
Your Honor, I apologize for the delay. If I can just have a minute to set up this body mic.
That's
make
fine.
It a little easier. Okay. So I don't think there's anything on the first instruction. But with respect to the second instruction, this is where both in this instruction as well as the first introductory instruction to phase one, where the court modified the instruction to inform the jury about the merger that will happen later, but telling the jury that they still need to make a determination on the 24 counts of first-degree murder.
Right.
And Your Honor, I just want to make sure, in case we were misunderstanding each other yesterday, our concern is not that the jury would not be informed of the merger. Our concern is that the merger actually happen. And so we have an objection to the way that the court has done this, because now we think this violates Caldwell versus Mississippi, because it conveys to the jury, or leads the jury to believe, that the ultimate responsibility for determining the defendant's sentence and the appropriateness of his sentence lies elsewhere. The concern is now you're telling them eventually these counts are going to merge, and eventually he'll be convicted and sentenced of 12 first-degree murders, but for the purposes of this hearing, you're going to make these determinations, and that improperly conveys to the jury that this ultimate decision about sentence and the ultimate imposition of sentence lies elsewhere, not with them. And that's why we think it's a problem under Caldwell versus Mississippi. So to be clear, we think both the way that the court originally proposed it and this modified instruction violate the Constitution, the 8th Amendment, the 5th Amendment, the 14th Amendment to the United States Constitution, as well as the Colorado Constitution, Article 2, Sections 16, 20, 23, and 25. If we're forced to choose between these two options, both of which we believe are unconstitutional, we would actually pick the version that the court originally distributed to the parties yesterday because we think this amendment has the additional constitutional issue that I just mentioned pertaining to Caldwell. So our request, again, is that the court merge the convictions, that the jury make all of their sentencing decisions based on 12 convictions and not 24 counts. But if the court is unpersuaded by that argument, our request would be to keep it as it was originally.
Okay, thank you. What's the people's response? Yes.
Your Honor, the issue in Caldwell was an argument that the jury was essentially told, hey, don't worry about this so much because there's going to be appeals and further things going down the road. Obviously, no one's going to argue that to them. Their decision is the sentence in the case. I guess I understand the argument that counsel is making, and I think that this does clarify things. I think that the issue of which they are complaining on this could be corrected by an additional sentence in that second to last paragraph in this instruction that indicates if you enter a death sentence, thus one death sentence will be entered for each murder, or something like that, so that the jury understands that it is, if they enter a death sentence, that is a death sentence, that it's not something that someone else gets to decide later on.
All right. Well, part of the argument that I heard yesterday from the defense had to do with how this was unfair in terms of the prior instruction. It was unfair because the jury would be misled into thinking that there were 24 counts still of first-degree murder and there would be 24 sentences. So today I'm hearing something different. I'm hearing that wasn't the argument. That was actually part of the argument because I was here yesterday when it was made. So the language in the instruction, although it doesn't grant what the defense was asking for yesterday, I believe it addresses the concern that was expressed yesterday, which is that the jury would be either uninformed or misinformed, and that somehow this would be unfair to the defendant because the jury would be thinking that it is passing sentence or passing a verdict, a sentencing verdict on 24 first-degree murders when, in fact, it's really only 12 as a result of the merger. There's no question that these will merge, that for each victim, the two guilty verdicts will merge into one. But the question as to when the merger happens is not clear, and there's no authority on point. The jury, of course, will make the sentencing decisions, but the jury doesn't actually impose the sentence. I impose whatever the jury decides, and as far as I can tell from the statute, that's what the legislature had in mind. In a typical criminal case, the way it would work, as you know, is that if there were 24 guilty verdicts for the killing of 12 victims because there were two theories of liability pursued by the prosecution with respect to each deceased victim, what would happen is the court would merge those before he or she imposed a sentence, and the court would then impose a sentence only on one first-degree murder. We all are in agreement that the defendant cannot stand convicted of 2 counts of first-degree murder for 1 killing. We all are in agreement also that the defendant cannot be sentenced twice for 1 killing. And that's what all this refers to. But the question is, at which point should the merger happen? And there isn't an ideal solution. The people articulated some concerns with doing the merger ahead of time. There are also some concerns, and Ms. Nelson has expressed those, with doing the merger later. So neither one is an ideal situation, and I have to choose one. I think that the better option is to choose the one that I've chosen, which is to go to wait until after the jury makes all the determinations that it's supposed to make. I will look at Caldwell, and then I will decide how to proceed. And what I may do is add a sentence, perhaps not the one that Mr. Orman suggested, but add a sentence and then go from there, to try to clarify that it is the jury that's making the decisions here in terms of the sentencing. And I'm not saying to the jury that they're not, so I don't think that the instruction as drafted conveys that message, and I'm not worried that the jury will be confused about that, but after I read Colwell, I may conclude that it bears adding a sentence to clarify that point. So I'll read Colwell, and then we'll proceed. What else do you have in terms of the final instructions, Ms. Nelson?
I just need to go through them page by page. So I don't think we have anything additional on the next instruction. I've numbered the pages. I think that may be the best way for me to refer to them. On reasonable doubt, we don't have anything else.
I'm following along.
Okay.
If you just say the next instruction, so.
Nothing on the next one. Nothing on the next one. Nothing on the next one. Nothing on the next one, which is direct and circumstantial evidence. Number of witnesses, nothing. Nothing on the next one. I should say nothing additional for all of these, and we're not waiving any of the objections and arguments that we made yesterday.
Correct.
I think that the only other issue we have with respect to the final instructions on phase one that we didn't raise already yesterday is in the last instruction that says following the attorney's arguments at the end of phase one.
Yes.
This is something we just caught this morning. I think this language was in there yesterday, and we didn't discuss it. The last sentence, your foreperson will preside over your deliberations and shall sign.
Yeah, we caught that too. Any part of a sentencing hearing phase one verdict form, right?
That was actually not what I was going to point out. We think it should just say, instead of any part of the foreperson will sign any part of a sentencing hearing verdict form that you may agree on, because the foreperson is going to sign the verdict form under Part 2 if the jury does not unanimously find the prosecution has proven beyond a reasonable doubt the existence of at least one of the aggravators. And so it's a little awkward to say that you may agree on when what they may be agreeing on is not to agree. So we would propose that the court rephrase to say, your foreperson will preside over your deliberations and shall sign the sentencing hearing verdict form for phase one according to the rules that I am about to explain. Does that make sense?
Any objection to that, Mr. Orman?
Thank you.
Yes.
We're okay with that, Your Honor.
Okay. I don't think that this is confusing the way it is, and this is similar to what the model instructions have it, but I don't have a problem changing it either, so I'll change it as Ms. Nelson has suggested, without objection.
Or the final phase one instructions.
Okay, great. Let's move on then to the introductory phase one instructions, the phase one introductory instructions. Do the people have any objections or any additional comments or any other instructions to tender with respect to the court's introductory comments at the beginning of the sentencing hearing?
Your Honor.
All right, does the defense, Ms. Nelson? I'm assuming the same issue that you talked about already with respect to the merger and Caldwell, correct?
Yes.
Okay.
And again, yes, and again, it's the concern is that the jury is making 24 findings on aggravators for no reason at all when they're actually, the convictions are going to ultimately merge. So there's absolutely no purpose in them doing so, but a great deal of prejudice to Mr. Holmes because they're having to consider double the amount of aggravators.
But I'm telling them now that these are going to merge and they're going to end up into 12. So I'm not sure where the prejudice is in that. I mean, that's why I included the language that I've included. And you know, we do the same thing before the jury deliberates at the guilt phase of the trial, right? I mean, we all know that the defendant cannot stand convicted of 2 counts for the same killing, and yet we have the jury deliberate on 2 counts for the same killing. All of us knowing and understanding that in the end, it's only going to be 1 first-degree murder conviction. And I explained that to the jury before, and at least in the current draft, it would be explained again, the whole idea of, you know, these are really 12 first-degree murders. It's just that there are 2 different theories of liability with respect to each deceased victim. You have murder in the first degree after deliberation and murder in the first degree extreme indifference. And the only question is, at which point does the merger take place? Does the merger take place? Should the merger take place now, and should the court take away the opportunity to have the jury deliberate on each count separately, or does the court wait until after the jury has made findings with respect to each count and then do the merger at that point before actually imposing the sentence, officially imposing and entering the sentences and doing the minimus? And again, it seems to me that between those two, understanding that there are disadvantages to each, that the better course of action is to do the latter. But having said all that, I have not read Caldwell anytime recently, so I'm going to go and read Caldwell, and if I think that this is problematic, then I may change my mind, or if I may think that a clarifying statement will take care of it, then I may do just that, okay? And obviously I would give you an opportunity to be heard on any change, any modification that I make. What else do you have, Ms. Nelson?
Your Honor, may I just cite one additional case to the court on this point?
Yes.
It's actually on the issue of duplicating the aggravators in general. It's not as to the separate and additional Caldwell issue that we think this new instruction poses. It's United States versus McCullough, MCCULLAH, 76 F 3rd 1087. It's a 10th Circuit case from 1997.
Tell me the site again.
76 F 3rd 1087. And it addresses the doubling up of aggravators and how that unconstitutionally skews the weighing process. It's a slightly different context. In that case, it had to do with 2 separate statutory aggravators that within the context of that case covered the same conduct. And so it was the double counting of the same aspect of the conduct twice. And the 10th Circuit held that that was an unconstitutional skewing of the weighing process and remanded for a new sentencing hearing.
Okay. Mr. Orman.
I think that issue was addressed in Davis, and I can't remember which Davis, and my internet browser's crashed, so I can't pull it up on Westlaw right now. But, well, I shouldn't say crashed, locked up, and I can't close it. So my understanding from Davis is that a very similar argument was made, and the Davis court said that in fact was not an issue. And I'm just talking about the argument of aggravators covering similar or identical conduct. So I don't think in Colorado that actually is an issue.
Okay.
I can respond to that, Your Honor, because I've looked into the Davis cases, so I can tell you exactly what happened.
All right.
The 10th Circuit in Davis, so the Colorado Supreme Court in the Davis opinion that came out in 1990, said that even if there was a doubling up of aggravators, that was harmless error. And then, well, that Davis in the 10th, they didn't reverse on that issue in the Colorado Supreme Court. And then the 10th Circuit reviewed the opinion and said, no, it is error, but they found it was harmless error within the context of that case. And so there was a dispute between the 10th Circuit and the Colorado Supreme Court on that issue. But we would cite to McCullough, which is a 1996 case from the 10th Circuit.
Okay, what else do you have with respect to the introductory instructions?
We would ask the court to consider adding on page 3, in the second paragraph, further, you should not infer from these introductory instructions that there will be a phase 2 or phase 3 in the sentencing hearing. I am giving you these introductory remarks about all 3 possible phases, even though we may never get to phase 2 or phase 3, because it is important. I think the court used some similar language during voir dire.
I don't have a problem with that, although it's stated in the sentence before it, but that's fine. Okay, what else?
Regarding that, I mean, the last words of the suggested instruction, the way it reads, I think on the transcript, are because that is important. I think that was argument from counsel, and she wasn't requesting that the words because it is important go in the instruction. But if she is, I would object to that. I don't see that that's necessary.
No, I'm leaving the rest of that sentence in there. I'm just adding a phrase in there, even though we may never get to phase 1 and phase 2.
I just stopped reading the sentence before the end of the sentence.
Okay, give me just a moment. Okay, what else?
On page 8, Your Honor, the first paragraph of that page, this is the paragraph that we discussed at length yesterday involving moral judgment and mercy having to be based on the evidence and information.
The first?
That was presented? Yes. And to be clear, we maintain our objection because it is our position that a juror's decision to exercise mercy does not have to be based or grounded in the specific evidence that's presented at trial. However, maintaining that objection, would the court consider changing the beginning of that sentence to say, your exercise of moral judgment and mercy must be based upon evidence and or information? That would at least alleviate the concern that we have that the juror's own moral judgment itself comes from the evidence. It's that the jurors come into the courtroom with their morality and then they exercise their moral judgment in the context of the case. So we would ask that the court consider changing the beginning of that sentence to read your exercise of moral judgment and mercy.
Mr. Orman?
I don't object to that.
Yeah, I think that's fine.
And so then we would ask that the same change be made, maintaining our previous objections to that paragraph, the same changes be made to that paragraph on page 9. It's the second full paragraph on page 9.
Okay, that's granted as well. What else?
And I think that's all.
Okay. All right, let's move on to the phase 2 instructions. These are the phase 2 introductory instructions.
Actually, Your Honor,
Oh,
before we
sorry.
do that, can I supplement my argument on the issue of the joinder question?
Yes,
The murder question?
yes.
You know, it occurs to us that one issue that I think supports the rationale for giving the jury separate decisions for each of the various theories of first-degree murder is that you could have a juror or jurors think, well, I don't think that I should impose a death sentence for extreme indifference. I only think I should impose a death sentence for after deliberation because the culpable mental state is different of the crimes, and in my exercise of judgment in phase 3, I think there's a different aspect to those crimes. And if you separate it out for them, like the court is planning on doing, they can actually make that decision. They can actually say, I'm looking at these two things separately and differently. And it affords them the opportunity to do so, whereas if we went with the way the defense is suggesting, the jurors wouldn't be able to do so, and they could actually think that they were sentencing someone under a theory for first-degree murder with a culpable mental state that they didn't think was appropriate for the death penalty in a Phase 3 analysis. So I think that is an additional rationale to separate them out and to not have the merger happen until after the jury makes its sentencing decision.
I think that the concern that Ms. Nelson raised yesterday, though, with that scenario, is that it could lead to inconsistent sentences. So, for example, they could say, well, we're going to return a sentencing verdict of death with respect to count 1 of first-degree murder after deliberation, but we're going to return a sentencing verdict of life with respect to count 13, which is the same victim, on extreme indifference murder. And so then what do you do in that situation? Because now you've got a merger. You have to merge counts 1 and 13. You have to impose just a single sentence, and now you have 2 sentencing decisions, one that says a sentence to death and the other one that says a life sentence. So that is one of the disadvantages, perhaps the major disadvantage with proceeding in the fashion of waiting to do the merger until after the jury has made findings with respect to each count.
Ron, I think under such circumstances, you merge and you go with the harsher sentence. I think that's the way we always do those things. So I think that there are differences in the culpable mental state of these offenses. So, and I could see a juror having to say, well, am I actually sentencing to death for the culpable mental state that I don't think it's appropriate when I want to sentence to death on the sentence or the culpable mental state I do think is appropriate? So, but frankly, Your Honor, I think it would be, the defendant would love to have that instead of death sentences for everything, would love to have that, and then they could argue that till the cows come home in the appellate courts. So frankly, I think that would benefit the defendant if that happened as opposed to just one death sentence for each murder.
Like I said, neither scenario is ideal. There are disadvantages with each scenario. We just highlighted that perhaps the major disadvantage with waiting to do the merger until later. The disadvantage with doing the merger now, before the jury gets this, is that I can see some problems later in terms of, well, we don't know which specific count the jury found the aggravators as to, and we don't know if there was unanimity with respect to that, because perhaps some jurors were thinking the aggravators applied to the count of first-degree murder after deliberation, but not with respect to the extreme indifference murder. Perhaps other jurors felt the opposite way. Perhaps some jurors felt that both applied. That's the problem. There's not a good solution, no matter how you look at it. And that's the difficulty in this. And those are the 2 choices I have. It's not like I have a different choice, a third choice that I can then just say, well, I'm going to avoid either of these problematic situations and choose something different. I don't see another option as of right now. So, all right, let's move on to the Phase 2. What about Phase 2? The Phase 2 introductory instructions. Do the people have any objections, any suggestions, or any additional instructions to tender? All right, what about the defense? Ms. Nelson?
We have a few things, Your Honor. First,
Yes.
First, with respect to that first paragraph on page 1, it just occurred to me that the court, obviously the court will take a look at this after we receive the verdicts in Phase 1, but the court just may need to modify it because right now it reads that they have unanimously found the existence of one or more aggravating factors with respect to each count. So I just wanted to flag that, in the event that they come back differently in different counts, the court may need to modify that.
Well, obviously, you submitted Phase 2 introductory instructions. I'm not taking that to mean that it's a foregone conclusion. We're just planning ahead at your request because you've indicated that you have some witnesses who have scheduling issues and you would like to call them on Wednesday. So, absolutely.
No, I understand that, Your Honor.
Absolutely. This is just right now hypothetical. We're just trying to do some work ahead of time, and I'll leave it up to you to remind me, obviously, if we need to make any modifications.
Third paragraph on page 1. we would request, I know that we state this multiple different ways in our proposed instruction, but we would ask that the court change that end of that first sentence, regardless of who presents it, to regardless of the source. We feel that that's more consistent with the United States Supreme Court's Eighth Amendment jurisprudence on mitigation.
I think we talked about the source yesterday, and my recollection is that there was an objection because it doesn't say what source. It's too vague, and I agreed with that objection. I don't know what that means. I mean, it could be an outside source. That would be improper. So if the point is that the defendant is not required to present mitigation, but the jury has to consider whatever mitigation is presented regardless of who presents it, then that point is being made. As to the other requested change, I don't have a problem doing it. So how would you like it to read? Instead of although the jury must consider all evidence of mitigation, you want it to read how?
No, that was the requested change.
Okay.
That was the only requested change.
Yeah, my recollection from yesterday is that there was an objection by the people to the use of the word source, and I sustained that objection. Am I misremembering that, folks?
We had a conversation about it at some point. I don't know if
Okay.
it was with respect to that particular sentence, which is why I wanted to raise it again.
My recollection is that it was with respect to that sentence.
Next page.
Now, if you want to find another way to say it where it's clear that we're talking about evidence presented, I don't have a problem with it. I just have a problem saying no matter what source, because I don't know what that means. Now, if it's related to the evidence and it's clear that it's related to the evidence, then it should be okay. So
I don't have any additional argument at this time on that issue. On the next page, page 2.
Actually, if I may, on that issue, now that I'm thinking about it, the way it works is no matter who presents it, almost makes it sound like it's a future thing, which it can be. But it can also be stuff from the prior trial that's already been presented. And I don't know if the court should just make that sort of tense change so that it would incorporate both stuff that's already come into evidence and stuff that will in the future.
do you have any objection to who presented it? And, looking at it again, Ms. Nelson, I'd be happy to say, regardless of who presented it or the source of that evidence.
We'll take that.
Okay. All right, what else?
Next page, first full paragraph, last sentence,
Okay, hold on. Which page?
second page.
Second page? Okay, give me a sec. Second page, what paragraph?
First full paragraph,
Okay.
that short paragraph about mitigation. We were wondering if the court would consider rephrasing that last sentence to state, instead of mitigation can also include facts or circumstance about the defendant, mitigation can also include facts or circumstances that bear on the defendant's moral culpability.
Any response?
I have an objection to that, Your Honor.
I think that's appropriate as well. So I will make that change. And this paragraph came from your tendered instruction, Ms. Nelson, and I did my best to put it in here as closely as what you had suggested in your tendered instruction, so. Okay, what else?
And then the last paragraph of that page, we're requesting that the court just include a phrase in that last sentence. When a juror has determined that a mitigating factor exists, and then include the phrase, a juror may give it any weight that he or she chooses, but the juror may not give it no weight by excluding it from his or her deliberations.
So it would read, when a juror has determined that a mitigating factor exists, the juror may give it any weight that he or she chooses, but the juror may not give it no weight by excluding it from his or her deliberations or refusing to give it meaningful consideration. I think that's appropriate. Is there any objection?
I don't object, Your Honor. The one thing I noticed looking at this is, and this is maybe semantics, but I think it's kind of an awkward sentence. You may not give it no weight. I'm just wondering if it'd be better to change no to 0 or something like that. It might read it a little easier.
Ms. Nelson, do you prefer 0 weight or no weight?
I don't have a strong feeling about that.
The
Yeah,
problem
Ms.
I have with 0 weight is that we tell them this is not a mathematical
process.
thing, so I would rather not use numbers.
We agree. That's what Ms. Higgs just pointed out to me. So I think we request to stick with no weight.
Okay. What else?
On the next page, page 3, the last sentence of the first paragraph.
Yeah, I didn't know how else to, I didn't like that sentence a whole lot, but I was trying to include the concept from your tender instruction, and that's the best I could do. Because I think if I give it, it has to be in an impartial and fair way, and I can't give it one-sided. This is the best I could come up with, but if you have a better suggestion, I'm open to it.
Well, I think the way we requested, I think the way we submitted it was just each juror may emphasize one factor more than another, and in the preceding sentence you're talking about we're mitigating and aggravating factors, and so I don't think there's anything objectionable about just saying each juror may emphasize one factor more than another, giving each factor as little or as much weight as the juror deems appropriate. I think if the court's not inclined to make that change, we would just ask the court to.
Hold on, I may be inclined to do that. Do the people have any objection to that?
Would read, each juror may emphasize one factor more than another? Or
Yeah.
I would say, I think it should have both in there, Your Honor, because I could see it being misinterpreted to mean mitigating factors and not aggravating factors. So I would ask that it stay as it is.
And again, I just don't see that concern given that you're referring to both in the sentence immediately preceding it. Or,
How about if I say, in weighing the mitigating factors and the aggravating factors, each juror may give one factor, each juror may emphasize one factor more than another, giving each factor as little or as much weight as the juror deems appropriate. Because then it's clear we're referring to both.
we're okay with that change, Your Honor.
Okay, that's what I'll do.
Your Honor, we're okay with that change, but the one thing I wonder about is by using the phrase one factor, is that somehow confusing? Because obviously there may be many factors that they consider. And so I maybe in saying one factor, just say factors. Instead of one, any factors, or something like that.
Each juror may emphasize any factor more than another, giving each factor as little or as much weight as the juror deems appropriate. That's fine too. I can say any instead of one. So it will read as follows. In weighing the mitigating factors and the aggravating factors, each juror may emphasize any factor more than another, giving each factor as little or as much weight as the juror deems appropriate, okay? All right, Ms. Nelson, what else?
I think perhaps, could the court say each juror may emphasize any factor or factors more than another?
I like it better the way it is, but do the people have a position? If the people agree, I'll change it, but I like it better the way it is. I think it's easier to understand. I think the point is made just by saying it the way it is.
I agree with Your Honor, but maybe a way to do it would be to say each instead of any.
Each juror may emphasize each factor more than another, giving each factor as little or as much weight as the juror deems appropriate. Ms. Nelson?
I like any. I think any is more
All
appropriate.
right, we'll leave it the way it is. Okay, what else, Ms. Nelson?
The bottom of page 3, we had some discussion about this yesterday, and after giving it some more reflection and thinking a little bit more about Caldwell versus Mississippi in relation to the merger issue, we would request that the court rephrase that last sentence. Otherwise, the sentencing hearing as to that count ends, and the defendant will be sentenced on that count to life imprisonment without the possibility of parole, just to make sure the jury understands that it is their responsibility to determine sentence, that their decision does control the outcome.
Any objection, Mr. Orman?
Your Honor.
That's fine. Okay, that's granted. What else?
And I'm not sure, but I think that may apply. It does apply actually as well, now that I'm looking at it, to a couple of places in the court's introductory instructions to phase 1.
Okay.
I think it's on page 7 when it's talking about the outcome of phase 2.
What part of page 7?
It's the last sentence of the first full paragraph. Otherwise, the sentencing hearing as to that count ends, and the court will sentence the defendant on that count to life in prison without the possibility of parole. I think
That's fine.
we would just say the defendant will be sentenced. And then same on top of page 9, if the jury is unable to reach a unanimous verdict on a count, the defendant will be sentenced to life.
Okay, got it.
Okay.
Anything else?
Your Honor, I mean, just on that last one though, isn't that a little different? Because on that circumstance, if they're unable to change, it really is the court imposing the sentence then, or unable to agree. And I just think that's a little bit of a different circumstance.
But, Your Honor, if they're unable to agree, the sentence is life. The court has no authority to change that sentence or that verdict. And so I think it's appropriate to convey to them, important to convey to them under Caldwell, that if they decide, if they cannot agree, the sentence is life, and that is what he will be sentenced to.
How does that violate Caldwell if I say to them, look, if you can't agree, if you can't reach a unanimous sentencing verdict, then you'll be discharged and the court will impose a life sentence? I don't know how that violates Caldwell. I mean, that's not taking the responsibility away from them. That's just informing them that if they're unable to reach a unanimous verdict, this is the result. So,
May I have a moment, Your Honor?
yeah. And that's what the statute says, by the way, 18.1.3.1201.
The concern, Your Honor, is that by conveying that if they're unable to reach a unanimous verdict, then the court will impose the sentence. It somehow implies, or it may imply or suggest to them that some sort of a failure on their part not to reach, and then as a result, not to reach a unanimous decision, and then as a result, the court has to impose some kind of default, versus that's a valid verdict that you're returning, even if you don't unanimously agree on the sentence.
Well, they're going to know that because I'm telling them that the only way they can return a sentence of death is if they are unanimously convinced beyond a reasonable doubt that that is the appropriate sentence. So if they're not unanimously convinced, then they know it's a life sentence. So
I understand, Your Honor. I think we feel that we need to convey to them as much as possible that it's still a verdict and it's a valid verdict to be non-unanimous because it is so different from the way that they are told to deliberate during the first phase of the trial. So
I'll make the change. I mean, it doesn't say anything that's incorrect under the law. It just says, it just changes the tense of the sentence. Instead of saying the court will sentence the defendant, it says the defendant will be sentenced. It just doesn't identify that it will be the court doing the sentencing. But I think they either way they get it, it's almost semantics. Either way they'll know this is the end result. So, okay, what else?
So going back to the introductory instructions for phase 2.
Oh, and by the way, I looked at Tennyson last night, and I continue to have the same position that I expressed yesterday. Tennyson was looking at the statute, the death penalty statute in effect at the time, and nothing in Tennyson reflects that the court disagreed with the plain meaning of the language used by the legislature. What Tennyson was trying to do is figure out the standard that applies. And the standard that applies in that particular aspect of the death penalty statute is beyond a reasonable doubt. That the jury has to be convinced beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors. Now, you can say it different ways, and they said it different ways throughout the opinion, but the bottom line is they said the same thing, just using different words. And you can drive yourself crazy if you wish and try to infer from it that it's the court was saying something different and changing the language of the statute. The court was not doing that. The court was passing judgment on what is the standard that applies. And what the court found is that the jury has to be convinced beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors. So having said that, I don't have a problem with the changes that you suggested, and I made the changes, but I want to be clear that in my view, this is saying the very same thing that I was saying before and the very same thing that is said in the statute. So, and the same thing that is said in Dunlap and any other cases that I've talked about this particular phase of a sentencing hearing. What else do you have, Ms. Nelson?
The last page of that first instruction, so page 4.
Yes?
Last paragraph. Same request that the court granted, just changing it to be I think it was either the exercise of or your exercise of.
Your exercise.
And we maintain our objections to that paragraph, but request that change be made.
Okay. What else?
And then the only other record I feel I need to make is with respect to the instruction on page 6. We continue to object to the language for the limited purpose of determining the existence or absence of any mitigating factor. I know we litigated this extensively, but I just wanted to make clear for the record that we continue to maintain our position that it violates Mr. Holmes's Fifth Amendment privilege against self-incrimination, as well as the same privilege against self-incrimination under the Colorado Constitution, to allow the prosecution to use any of this information to prove the absence of any mitigating factor or to rebut any mitigating factor. And I would just refer back to the arguments and authorities that we made and cited in motions D32, 187, 248, and 264A.
All right, and I'll stand on the orders that I issued with respect to those motions. The statute is clear on this, and I'm following the statute. I'm bound by the statute. The argument that was made yesterday is that this somehow would violate the holding in Dunlap that said the prosecution cannot present evidence of the absence of a mitigating factor that the defense does not present evidence on. And this instruction in no way allows the prosecution to introduce evidence of the absence of a mitigating factor that the defense does not present evidence in support of. This is just an instruction following the statute. The statute is clear that the jury in phase 2 of the sentencing hearing can consider evidence admitted at trial for the limited purpose of considering the issues raised by the defendant's plea of not guilty by reason of insanity for a different limited purpose. That different limited purpose is to determine the existence or absence of any mitigating factor. So, and I thought about it last night, and the statute is clear on this, and I have to follow the statute. So I am bound by the statutes in Colorado. I took an oath to follow the law. I have to follow the law. That's the law. Is there anything else at this time that we need to talk about with respect to instructions on behalf of the people?
Not regarding the instructions, Your Honor.
All right. Anything else on behalf of the defense with respect to instructions? These instructions anyway. Ms. Nelson?
No, Your Honor.
Okay.
I,
All right, I'll take the no. You don't have to explain. Thank you. Is this a good time to talk about the Curtis advisement with your client, Ms. Nelson? Or Ms. Brady?
Yes, sir.
Okay. Before I do the Curtis advisement, perhaps we should have a discussion about the right to make an allocution statement. Yesterday, we had a discussion about that. It seems clear to me that there's no disagreement between the parties that the defendant has a right to make such a statement in phase 2 and in phase 3. The question is, does he have a right to make it in phase 1? I think the people yesterday either expressly or impliedly said no. Does the defense have a different position with respect to that? Ms. Brady?
Your Honor, I don't know of any authority for this, but I guess to be on the safe side, I would allege if we're sending the jury out 3 separate times that he has the right to allocution 3 separate times.
That's my inclination as well. So I'm going to give him an allocution advisement, and if Mr. Holmes wants to make an allocution statement tomorrow, I'll give him an opportunity to do that before the parties make argument. So he'll have an opportunity to do that. So let me start with the Curtis advisement, and then we'll proceed with the allocution advisement. All right, Mr. Holmes, I need to speak to you directly at this time. Can you hear me okay?
Yes.
If there is anything I say to you that you do not understand or do not hear clearly, please let me know that, okay? Mr. Holmes, I need to advise you that you have a right to testify in this sentencing hearing, and specifically in phase 1 of the sentencing hearing. And if there is a phase 2, then you'll have a right to testify in phase 2 as well. And if there is a phase 3, you'll have a right to testify in phase 3 as well. But right now, we're dealing with phase 1, so we're going to stick with phase 1. I need you to understand that you have a right to testify in phase 1. And a moment ago, I mentioned the right to make an allocution statement. That's different than your right to testify. I don't know whether you've had an opportunity to talk to your attorneys about that, but if you're unclear about that, I would give you additional time to speak to your attorneys about that. Would you like additional time to speak to them about the difference between your right to testify and your right to make an allocution statement?
No.
No? Okay. Do you understand both of those rights?
Yeah.
All right. Let's get to the right to testify then in phase 1 of the sentencing hearing. If you want to testify in phase 1 of the sentencing hearing, no one can prevent you from doing so. You may take the witness stand and testify even if it is contrary to the advice of your attorneys. If you want to testify, no one can prevent you from doing so. If you were to testify, then the district attorney would be allowed to cross-examine you. And you've seen how witnesses have been cross-examined throughout the proceedings in this case. It would be similar to that, except that Instead of your attorneys doing the cross-examination, it would be the district attorney doing the cross-examination, just as the district attorneys cross-examined any witnesses that your lawyers called on your behalf during the trial. If you have been convicted of any felonies, the district attorney would be entitled to ask you about those convictions and thereby disclose those convictions to the jury. And we've made a record of this twice now, but I'm going to have the district attorney state again that confirm for me again that they are not aware of any felony convictions for the defendant.
That is correct, Your Honor.
Mr. Holmes, in this case, jurors are permitted to submit written questions that they would like to have asked of witnesses. The same rules of law, including the same rules of evidence that apply to attorney questions, also apply to juror questions. The court will not permit improper juror questions to be asked of any witness, and that would be the case if you took the witness stand. If you decide to testify, and if the jury submits one or more questions that the court determines are legally proper to be asked, you will be asked those questions. And you've seen the process that we've followed throughout the proceedings. If the jury has a question, the jury puts it in writing. My staff brings the question to me. I call the attorneys to the bench. We have a bench conference. I rule on any objections that may be advanced with respect to a question. If I find that a question is not appropriate, I do not ask the witness the question. If I find that a question is appropriate based on the rules of evidence and other applicable rules of law, I ask the witness the question and give the witness an opportunity to answer the question. And then I give each side, starting with the side that called the witness, an opportunity to ask follow-up questions. That same process would be followed with you if you took the witness stand. I mentioned that you have the right to testify in this case. I need to also advise you about your right not to testify. Again, we're talking about phase one of the sentencing hearing right now, so we'll limit it to that. You are protected by a constitutional provision against self-incrimination. Therefore, you do not have to testify if you do not wish to do so. If you choose not to testify, then the jury will be instructed about that right, and that no negative inference can be drawn from the fact that you choose not to testify in phase one of the sentencing hearing. Let me read you at this time the instruction, the specific instruction that I would give the jury on this point, and I would only give it with your attorney's consent. If your attorneys ask me not to give it, then I will not give it, but your attorneys have asked me to give it, so I'm planning on giving it. Let me find it in here, and then I'm going to give it to you, just so that you know exactly what it is. It reads as follows. Every defendant has a constitutional right not to testify. The decision not to testify cannot be used as a negative inference and cannot prejudice the defendant. It is not evidence, does not prove anything, and must not be considered for any purpose. Although the defendant has been found guilty of murder in the first degree, he retains his constitutional right not to testify during the sentencing hearing. The defendant exercised his constitutional right not to testify during the trial and phase one of the sentencing hearing. You shall not draw any negative inference from the defendant's exercise of his constitutional right not to testify. The exercise of this constitutional right cannot prejudice the defendant in any way. The defendant's exercise of his constitutional right not to testify cannot be used as a reason to find that the prosecution has proven any alleged aggravating factor. If you elect not to testify with your attorney's consent, that's the instruction that I would give the jury before they deliberate at the end of phase one. The decision of whether or not to testify in phase one of the sentencing hearing is a decision that must be made by you and by you alone. It is a personal decision. In this case, you've been advised and represented by Ms. Brady, Ms. Higgs, Ms. Nelson, Mr. King, and Ms. Spengler, and right now present with you are Ms. Brady, Ms. Higgs, and Ms. Nelson, all of these folks are experienced and skilled attorneys. And I encourage you, if you haven't done so already, to discuss this with them. It is always, I think, a good idea for a defendant to discuss his right to testify and his right not to testify in a proceeding, including in phase one of a sentencing hearing. But ultimately, this is your decision, and it is a personal decision, and you make that decision even if they disagree with the decision that you make. Does all of that make sense to you?
Yes.
Have you discussed with your attorneys whether or not you will testify in phase one of the sentencing hearing?
Yes.
Have you had enough time to discuss this matter with your attorneys?
Yes.
Do you need more time to talk with your attorneys about this particular matter?
No.
Have you made a decision as to whether or not you will testify in phase one of the sentencing hearing?
Yes.
And what is your decision?
I don't want to testify.
Okay. Is this a voluntary decision? That is to say, one that is not, well, let me ask it in two parts. Is this a voluntary decision?
Yes.
Is this a decision that you have made as a result of pressure, influence, threats, promises, or coercion?
No.
Do you have any questions for me about the advisement that I just gave you?
No.
Do you need more time to talk to your attorneys about your right to testify and your right not to testify in phase one of the sentencing hearing?
No.
Do you understand both your right to testify and your right not to testify in phase one of the sentencing hearing?
Yes.
Is there any other record that the people would like me to make, or any other questions that people would like me to ask?
No, Your Honor, thank you.
Ms. Brady, any other record that you would like me to make, or any other questions that you would like me to ask?
No, sir.
All right. Mr. Holmes, based on, and everyone, based on my discussions with Mr. Holmes, I find that his decision to not testify in phase one of the sentencing hearing is one that has been made knowingly, voluntarily, and intelligently. All right, let's move on then to the right to make an allocution statement. Is it okay if we proceed with that at this time, Ms. Brady?
Yes, sir.
All right. Mr. Holmes, I need to speak to you directly again. Can you hear me still okay?
Yes.
All right. Again, if at some point you don't hear me well or you don't understand something I say, please let me know, okay?
All right.
Do you understand that you have the right to allocution?
Yes.
And do you understand what that means?
Yes.
Have you discussed that with your attorneys?
Yes.
Do you understand that if you make a statement of allocution, you will not be under oath?
Oh, yes.
Do you understand that if you make a statement of allocution, you will not be cross-examined?
Yes.
Do you understand that if you want to make a statement of allocution, no one can prevent you from doing so?
Yes.
Do you understand that you do not have to make a statement of allocution and no one can require you to make a statement of allocution?
Yes.
Do you understand that if you decide not to make a statement of allocution, the jury will not be advised in any way that you have decided not to make a statement of allocution to them?
Yes.
And again, you've consulted with your attorneys concerning this issue, is that right?
Yes.
And have you had enough time to talk to them?
Yes.
Are you satisfied with the advice of your attorneys concerning this particular issue?
Yes.
Do you desire more time to discuss this issue with your attorneys?
No.
Whether or not you give a statement of allocution is your personal choice. Although you may have consulted with your attorneys and they may have given you advice on this issue, do you understand that whether or not you make a statement, you give a statement of allocution, is your choice, and that is your personal choice and not your attorney's choice?
I understand.
And again, I encourage you to talk to your attorneys about this, but in the end, it's your personal choice. Do you understand that?
Yes.
Whatever your decision is it your free and voluntary choice and your own personal decision?
Yes.
Do you have any questions for the court before I ask you for your decision?
No.
Do you need more time to make this decision, or have you made a decision?
I made a decision.
Do you want to make a statement of allocution in phase one of the sentencing hearing?
No, I do not.
No. Okay. And Mr. Holmes, we will go through this again if there is a second phase, and we'll go through it again if there is a third phase. Do you understand that?
Yes.
Okay. Is there any other record that the people want me to make, or any other questions that people want me to ask? Any other record that you want me to make, Ms. Brady, or any other questions that you want me to ask?
No, sir.
All right, based on my discussion with Mr. Holmes, I find that his decision to not make an allocution statement is one that has been made knowingly, voluntarily, and intelligently. And again, we're dealing right now with his decision to not make an allocution statement in phase one of the sentencing hearing. All right, is there anything else we need to take up at this time, other than what I said I would do in terms of the Caldwell issue, that I would we'll look into it and I'll make a final decision as to how I proceed with respect to that issue?
Your Honor, just one question. When we had the jury instructions for the guilt phase of the trial, the court sent us both Word and PDF copies of that the day before so that we could incorporate them into presentations for the jury. Will you do that again for us with these?
I can do that again. I will do that again for you. Yes.
Your Honor.
Okay. Anything else on behalf of the defense?
Yes, just very quickly, Your Honor.
Yes. Ms. Higgs?
We made a copy of the deposition from yesterday. I've given the prosecution a copy of this. I'd like to lodge this with the court as a court exhibit. I've asked the prosecution to listen to it because you can tell that people are talking at the bench conference. I don't think you can hear exactly what's being said, but we may decide to redact a portion of it, and I just want to make the court aware of that. We would give the court another copy if we come to that conclusion.
Okay.
So I have that for the court. I don't have anything further to add with regard to our witness, Jane Josephs. I will, though, tender our reports of our interviews with her and would like to mark that as a court exhibit as well. And lastly, Your Honor, I understand that based on news reports that there was a ceremony yesterday publicly with regard to the victims in this case. And I believe that it's appropriate to tender these articles sort of describing what that was to the court as a court's exhibit. And I think that because it was publicly done, I don't know if any jurors had exposure to it, drove past it, saw it. And I think that the court should make an inquiry under Harper, albeit I think in an indirect way, and not point out that there was a ceremony, but I think that we should know whether the jury has been influenced by this.
All right.
So I would tender that as a court exhibit, or?
Mark, why don't you mark it as a court exhibit?
Okay.
And then in terms of the witness, is it Jane Joseph? Is that her name?
Yeah. Oh, yes.
Yesterday you asked me for permission to wait until today to supplement your record with respect to that, and you're saying you don't have anything else to say about that?
No additional argument.
Okay.
I just think that I'd like to submit the reports and the court can review them.
That's fine. Then my preliminary ruling yesterday becomes final, and my ruling was based on the offer of proof that was made here in court by Ms. Teach McGuire and Ms. Higgs. If that's all this witness is intending to testify, that information is irrelevant and inadmissible for the reasons I stated yesterday. If there's something else, then I need to hear about it. But what I heard yesterday is that she was going to testify in general about her knowledge of the defendant's mother and the fact that she attends a particular church and that she has known her for a long time, and she would talk about the impact that the shooting and the other events that are at issue in this trial have had on her. And I ruled that although this may go to her character, it doesn't go to his character in terms of her attending that church and the witness's knowledge of the defendant's mother. That may go to the defendant's mother's character and background and history. I don't believe it goes to the defendant's character, background, and history specifically. And then in terms of the impact evidence, again, I'm aware of victim impact evidence being allowed in a sentencing hearing if there is a phase 3. I'm not aware of such evidence being allowed with respect to the defendant or the defendant's relatives. And what I said yesterday is, if you have any authority that says otherwise, I would be happy to see it. Nothing else has been tendered, so I'm assuming there's nothing else out there. As far as I know, there's not. So based on my understanding of the law, the ruling that was made yesterday, which was preliminary, is now made final for the reasons I stated yesterday and today. You may tender that report, Ms. Hicks, just let me know what you're going to mark it as, and then let me know what you're marking the DVD from the videotape deposition as well.
What number are we on?
91. So which one are you going to mark C-TR-91?
That will be the DVD of the deposition, and 92 will be the reports with regard to our witness, and 93 will be some media articles with regard to the ceremony yesterday for the victims.
In terms of the request for the question of the jury tomorrow, do the people have a position, Mr. Orman?
I guess before I have a position, I would need to know what the question would be. I mean, this jury has been very proactive in letting us know if they've come across news reports or information related to the case and has reported it to the court. So I don't think it's necessary. I guess I might take a position of that I don't object if I heard a specific proposed question that I didn't think was inappropriate. But I don't think it is necessary. And yesterday, for the record, was the 3rd anniversary of what happened in the theater, and that is why the services happened. I wasn't at any services, so I don't know exactly what happened, and I haven't read these news reports. But I just don't think it is necessary.
Ms. Hicks, what is the question that you would like me to ask the jury?
Your Honor, I just saw these media reports this morning. I haven't come up with the language of the question, but we would ask the court to do it in a similar way that the court questioned the jury with regard to the Boston verdicts, which was indirect and not telling them about what happened. But this ceremony yesterday was done out on a public street near the theater, and I don't know about these jurors in particular, but I do remember jurors through the course of individual voir dire mentioning that they either live near there or have gone to that theater or drive by there, and that's our concern. Not that they would have necessarily intentionally gone, but that they may have driven by and understood what was happening. May I approach with these?
You may.
Thank you.
You know, it was easier with the Boston case because I could specifically refer to the Boston Marathon trial. If I say to them, there was some media coverage of this case yesterday, was anyway, and go from there. I mean, there's been media coverage of this trial basically every day for the past months and months. So that's the concern with trying to come up with a question that makes sense and doesn't call more attention to the event. I don't want to mention specifically the ceremonies that were held, but All right, how about something along the lines of the following? There was some media coverage yesterday about the incident involved in this case. To the extent that any of you was exposed to those reports, do you feel it will affect your ability to discharge your duties as a juror, in this case, pursuant to the oath you took? That's as general as I can make it.
Your Honor, we've had a moment to discuss it, and our thought is perhaps you can just inquire of the jury, since you have returned your verdicts, have you been exposed to any additional information or media coverage about this case?
What's the people's position on that question?
We could ask that question every day. Have you seen any additional media coverage about this case or been exposed to it? It sort of seems like now the request has changed. It was limited to this particular incident. And, one thing I would note is, and I thought I heard Ms. Higgs saying this, is that she was also concerned that the jurors may have sort of been driving around the area and come across one of these events sort of by happenstance and seen it and figured out what it was. And that goes beyond media coverage. And maybe that's why she phrased her request in terms of information, but I don't know that that's even information. So I still don't think anything is necessary, Your Honor. I think that the question you asked, it would be appropriate, but I don't like the idea of coming to these jurors every day and saying, have you heard anything? Have you heard anything? They know not to watch or hear anything, and they let us know when they have.
Yeah, I agree with Mr. Orman. So what I'll do is I'll just include it in my admonishments, and I'll continue to give him the admonishments, and I'll continue to say what I've been saying, which is if at some point, despite your best efforts, you find out something about the case, then you need to let us know. And they have been really good about letting us know when something happens. Sometimes they've let us know about things that seem really almost silly, but they're being that careful, such as, for example, one time they let us know that one of them ran into an excused juror in the bathroom as she opened the door. But, that juror wanted to be careful, and she let us know about that. So I think what I'll do is I'll just add the language about even if despite your best efforts, you violate one of these admonishments inadvertently, then you need to let us know that, and you need to let us know that by telling my bailiffs that you need to talk to me. I think that's the best way to proceed.
And, Your Honor, just to make sure the record is complete, I agree that some of these jurors have been very forthright with us. We have not heard a peep out of some of them, and as this court has experienced in this case, there have been some jurors that have not been forthright and have not been upfront about outside communications involving this case. We are not asking the court to ask them every single day whether they've heard any media, but the reality is that they returned a verdict last Thursday. They have been away from the court for a significant number of days. In that interim, a significant event has occurred publicly, directly related to this case, that it's possible that they were exposed to. We don't want to highlight for them that the anniversary of this tragedy occurred yesterday. I don't think that that's appropriate. I think they probably know that in their minds, but to highlight yesterday at the date is not appropriate. But it is appropriate to ask them if since that time, last Thursday, over the many days that they've been gone, if they've been exposed to anything else. And yes, I think driving by and understanding that a memorial service going on is actually information, contrary to Mr. Orman's thought. Whether they have been exposed to anything else. I think that is appropriate, and we are making that request under Mr. Holmes' right to due process, to his right to a fair trial, his right to a fair and impartial jury, his right to a fair and reliable sentencing hearing under both United States and Colorado constitutions.
All right, thank you. My ruling stands. You can't say, Judge, we want you to ask him because some of these jurors are not being truthful. I mean, that doesn't make any sense. If I'm going to ask him the question, it's because we're relying on what they tell us. Otherwise, what's the point of asking the question? Either these jurors are forthright or they're not. And if they're forthright, then they're being forthright in terms of my admonishments, and they're being forthright in terms of telling me when there's a violation, even if it's inadvertent. If they're not forthright, then we've got problems, and a question from me is not going to fix it. Because if they're not being forthright anyway, and they're concealing things from me, and they're deceiving us, then the fact that I ask a question is not going to make any difference. So, we can't think about it both ways and say, well, you need to ask them because they may have been exposed to the media reports, but then say that they're not being forthright, or it's possible they're not being forthright. So I think the jurors are being forthright. I think they're doing their best, and I think they're complying with all my admonishments. We have dismissed some jurors that we found out were not being completely forthright, and I have made a record of that, and those people are gone. If I find out someone else is not being forthright or honest with me and is not reliable, then that person will be gone as well. But I don't see how a question for me will be valuable or any more valuable than the approach that I'm taking, which is to add it to my admonishments, to say, hey, if despite your best efforts, you have inadvertently violated one of these admonishments, that you need to let us know and let my staff know that you need to talk to us. And that'll include the admonishment that talks about not receiving any information from the media or any information from any outside source about this case. So, all right, folks, that's the, yes. What else?
I have one additional authority I would like to cite to the court on this Caldwell issue.
On which issue?
The Caldwell versus Mississippi issue in
Go
terms
ahead.
of telling the jury about the eventual merger.
Yes.
People versus Drake. It's a Colorado Supreme Court case from 1998. The citation is 748 P. 2nd, 1237. I just wanted to take a look to see if there were any Colorado-specific decisions applying Caldwell, and I found this case. It's a case in which the prosecution, it was involved in an improper closing argument by the prosecution, telling the jury that they had a shared responsibility and that you don't directly administer this, that job goes to the court. And the Colorado Supreme Court vacated the death sentence in that case, and this was one of the things they relied upon, and they said that the prosecution's comments implied that the jury had only an indirect or advisory role rather than the ultimate role in the imposition of the sentence, and concluded that argument contributed to the unreliability of the sentence in that case.
Got it. Okay. Anything else, Ms. Tisch-McGuire?
Thank you, Your Honor. Your Honor, I just wanted to clarify the court's ruling based on JJ, the witness that we talked about previously, that this would go for any other potential mitigation witnesses as to when they're testifying about victim impact, like testimony, that would be improper for the sentencing phase. And I just want to clarify that because in the 40 some odd witnesses that we've been reviewing, some of them certainly have observations that could go to the character, history, or background of the defendant, but also in those reports we received lots of information that was more victim impact type testimony, and I just wanted to make sure that the court, exactly, and the court knows what I mean by victim impact. Mr. Orman wants me to clarify it, and I think that's appropriate. It's certainly not victim impact evidence. It would be the impact on the defendant's family, and so we don't believe that that's proper evidence in the sentencing phase based on the court's ruling. We just wanted to clarify. For instance, I have another witness, SZ, who is the defendant's father's manager, and it appears that he maybe went to one barbecue and observed the defendant, and we have no objection to him testifying about his personal observations of the defendant at that barbecue. But the rest of all of the reports we've received are just victim impact evidence about the defendant's father at his workplace, and then hearsay evidence about the defendant's mother through the defendant's father, or hearsay evidence about the defendant through the father. And we would ask that that type of evidence be excluded as well, pursuant to the same order that the court issued about witness JJ.
Well, if there is any evidence that you think is objectionable, make an objection, and I'll rule on the objection. Obviously, the rules of evidence apply in a sentencing hearing. I have determined that already. So the hearsay rule applies. If there's an exception to the hearsay rule, then I'll hear about it. But otherwise, hearsay is inadmissible. If something is hearsay and there's no exception that applies, then it should not be presented. In terms of the ruling I made yesterday, of course, it applies throughout. It doesn't apply just to this witness. I'm not aware of any authority, as I said before, that allows for victim impact type evidence to be introduced by the defendant in a sentencing hearing. Victim impact evidence, as far as I know, from the authority that I'm aware of and all the case law, is limited to impact that a crime has had on a victim of the crime, not the impact that a crime has had on the defendant or the defendant's relatives, or family members or friends. So yeah, that ruling obviously is consistent throughout and has to be applied consistently throughout. All right?
Thank you, Your Honor.
All right, Ms. Brady?
Your Honor, in our response to P52, we did, I think, address some of the impact on the parents' issues that the court is talking about, so we would rely on our response to P52.
Okay, give me just a second. In motion P52, the prosecution moved in limine to exclude from any capital sentencing hearing all execution impact evidence, an argument as irrelevant to the defendant's character and criminal record or to the circumstances of the offenses charged. More specifically, the prosecution asked the court to enter an order prohibiting any evidence or argument pertaining to the impact that any execution of the defendant might have on his family, friends, or others. The defendant opposed the motion, and for the reasons stated in order P52, I granted the people's motion. So I stand by order P52 for the reasons I stated in that order and based on the authority that I cited in that order. All right, is there anything else at this time from anyone? Okay, great. I'll see everyone tomorrow then. Tomorrow we're starting at 8:40, all right? So see everyone tomorrow at 8:40. The court will be in recess. Thank you.